Hello everybody, Namaste. Welcome back to my YouTube channel. I'm Anushka, yet here again with yet another video. Today we'll be discussing about what is patent and eligibility to get a patent. Before getting into what is a patent can be simply understood as an exclusive right given to the innovators or someone who creates something new. So basically, when you want to safeguard your creation, you apply for patents. And why do you want to safeguard your creation? So that anybody else cannot use it without your permission or cannot plagiarize your invention. So, patent can be a method to secure your invention so that the novelty that you have added to the society comes under your name, plus it is not undertaken by someone else, which comes under plagiarism. I'll also be discussing about what is plagiarism, what are the contents that can be patented, and the things that cannot be patented will be discussed further. So we can understand patent as securing your invention, a guide to patents. Welcome to this presentation on the world of patents, a crucial tool for inventors and entrepreneurs seeking to protect and commercialize their innovative ideas. Throughout this guide, what we'll be exploring is the fundamentals of patents, the criteria for patentability, the intricacies of the application process, and we'll join us. You guys will join me basically, sorry, to unravel the path to securing your invention. So, what is a patent? A patent can be understood as an exclusive right of the innovator. It can also be understood as a legal document that is given to the inventor, which is basically an exclusive right to make, use, sell, or import their invention for a set period of time. So, basically, when you apply for a patent is nothing but a legal document that has two forms, Form A and Form B. But it basically includes your name, the people who are included with you, if there are any, and the country that you're from. So a patent is granted to a person from which geographical area they belong. So it is basically a legal document that helps you secure an invention. Now, why should you secure an invention? Number one, you can commercialize it. If it is a tool or if it is a machinery, complex machinery, you can commercialize it so that other country or any other person who wishes to have an access to it needs to pay you some amount. Isn't it great? You can make some extra bucks. Number two is so that the item that you have made or the product that you have created, you are the inventor. So hence nobody else can take it under their name. This comes under plagiarism. What is plagiarism? Plagiarism is an act in which the person implies that the invention or the creation is their own, but it isn't. In other words, it's basically a method of copying and making sure that other people assume that it is theirs, but it isn't. So to avoid plagiarism, patents are very important. Also, since you're adding novelty to the society, isn't it good to have it under your name? It would People will recognize you and you are adding novelty. So patents are hence important. What is a patent? Exclusive rights. A patent grants you the exclusive right to make, use, and sell your invention for a specific period, as I've explained earlier. This means no one else can produce, use, or sell your invention without your permission. So you are the owner of your invention, and hence people should ask you the permission to do so. So, what are the products that can be patented? Devices, drugs, pharmaceutical drugs, because of the chemicals that are being used, computer, machineries, any such invention that has a physical importance. What cannot be patented is a plan. Suppose if I have a plan to make a machine, I cannot patent it. But once I make the machine, that can be patented. So a plan, artistic creation, rather comes under copyright, which is basically to protect your artistic image. But patent comes for physically important devices, such as any machinery, or any electronic device that can be understood under patents. Patents are basically for physical objects, but copyrights are rather for the artistic approach of a person. Protection against infringement. What is infringement? In simple word, it basically means violation or limiting something. So if someone else infringes on your patent, that means limits your patent by making sure that their name is, by making sure it's seen as it's their own, you can take a legal action against them. Or they claiming, if XYZ person is making a patent for his invention, his or her invention, if there is another person, suppose me, who is claiming that that is my invention as well, or I had this idea, or maybe it's my product, looking at the patent, if the patent is under XYZ names, then I'm infringing it. Basically, I'm limiting that patent. So he or she can take legal actions against me because I am trying to plagiarize that. Number one. Number two is I am claiming or I'm making sure that I'm coming in between the patenting process without having any evidence or perhaps just for the sake of it. So that is infringement. That means I'm limiting the process. So this can be avoided altogether with all the documentation. That is that exclusive right of that XYZ person, that that is a product made by me. That is mine. And hence it cannot be taken under by me. If someone else infringes on your patent, you can take legal actions against them. This protection can be crucial for safeguarding your invention and your businesses. A patent usually lasts from 15 to 20 years, depending on what product you're trying to patent. So it can last from 15 to 20 years from the date of a registration of the patent. Requirement for patentability. Now, patentability has certain criteria, whether the object, now you know what objects can be patented, but among these objects, what are the criteria that need to be satisfied? First of all is novelty. What do you understand by novelty? Novelty is nothing but adding something new. Now, example, you have a recipe that's been throughout your family, all right, and you add something new to it. So now you are adding a novelty to the recipe. That is, you're adding your uniqueness, your new touch. So novelty is nothing but adding something new or adding or giving something new to the society. And for novelty and for new, and it is basically you're making something unique, one of a kind. Your invention must be new and not previously described or used anywhere in the world. Non-obviousness. Your invention must not be obvious to someone skilled in the relevant field. It shouldn't be obvious. Like it should be something that's out of the box, not something that already exists. Utility. Your invention must be practically used. Now, the invention that you made needs to have some importance, like some practical importance. Suppose I make a device like a calculator, for example, which was made hundreds of years ago, and this is a utility product because it has practical use, all right? Or any other product that has some use which you will use. You mean you doesn't not mean an individual, but for the society, because a calculator may be useful to me but not to someone else who doesn't have that degree. Yet it has some utility because it might not be useful to an individual but to the society. So utility here comes for the society, not just an individual. Your invention must have a practical use, meaning it must actually work and solve a problem. What is my calculator doing? The scientific calculator makes the job of calculating big and complex mathematical equation easy, which will help me save time. Enability, enability, sorry, enablement. Uh, your patent application must describe the invention in enough detail so that someone skilled in the field could make and use it. So you need to make sure the product is enabling as in making sure they give the ability to other people to use it. So enablement. Now, novelty, number one, includes new, not previously described or used. It should be unique, it should not be something that is already existing. The product cannot be the same, unpublished. So it should be not publicly disclosed before filing. Non-obviousness. It should solve some problem. An unsolved problem addresses a challenge not easily solved by existing technologies. Unexpected results. Delivers a result that was not anticipated or predictable. So it tries to give an answer to a problem. A surprising advancement offers a notable leap forward in a scientific field or technology. Now, utility means how useful it is, which will include practical use, should have a real world application, should be able to solve problems, rather not just a simple invention. Try to add novelty by solving issues. Workable. It should be workable. It should be functional. It should be capable and functional. The patent application process. Here are certain guidelines that you need to follow, or perhaps a flow chart of how it goes about with. First of all, you need to prepare. So, preparation, drafting a detailed patent application, filing, submitting the application to the patent office, for which you will require someone who can issue a patent, reviewing an examination, patent office assessment for patentability, insurance, issuance or rejection. So, granting or denying the patent based on your review. So, these are the four guidelines that need to be followed. Preparation, preparing the patent application. So, what you need to do is have a detailed description, which will include drawing, specification, and how the invention works. Claims, clearly define the scope of your invention and what you want to protect. Prior art search. You need to identify that the existing technology or invention that may be relevant to your invention, however, is not the same, so that they know what is the basis of your patent. Then you have filing application. So this may include submission, submit the application to the appropriate patent office, filing fee, may pay the required filing fee for processing the application. This will vary from country to country. The patent office will review your application for completeness. Patent office review and examination, technical review. Examiner assesses novelty, non-obviousness, and utility. Prior art search will compare the invention to the existing technology and sees if you have added something new or is it just something that's already existing. You have given some other name. Communication and response. Examiner may issue office actions and request for clarification or amendments. Final decision. The patent office will decide whether to grant you a patent or to reject your application. I hope this makes the topic a little bit easier for you to understand. If you have any doubts, feel free to comment down below. I'll try to solve it. Till then, stay safe, stay happy. Thank you so much for watching. I'll see you in the next one. Bye bye.